At first, state prosecutors made it clear, no bond, no release, Quadajah Johnson stays in jail. But her defense team didn't accept that. They appealed, and they won. The appellate court said the state failed to prove that Quadajah Johnson was such a danger that she had to remain locked up before trial. That should have been a turning point, right? But oh no, the state wasn't done. They came right back and said, wait, pause everything. They asked the appellate court for a stay so they could take the fight to the Illinois Supreme Court, and the appellate court agreed and granted the stay. Then, just like that, the decision was frozen. Quadajah Johnson remained behind bars. But now, her attorney, Ari Williams, pushed back yet again. She just filed a brand new motion that essentially says, you already ruled. You already decided. Now take it back and let her go. And that's where we are today. When people do the most, I do the analysis. Let's go. So here's the question. Why is Quadajah Johnson still locked up? Because the defense is fighting back. And this latest filing could determine whether Quadajah walks out of jail on pretrial release or stays behind bars even longer. Let's break this down step by step because things are moving pretty fast. On April 20th, the appellate court ruled in Quadajah Johnson's favor. They said the state failed to prove that she was such a danger and that she needed to remain detained. That's a big deal because that's what really set this ball in motion. The appellate court said that it's an undisputed fact that Ramika Blackman was the aggressor. And I'm sorry, but that's just not true. It's actually a highly disputed allegation made by witness number 1, Carlos Smith, and the state has already deemed Carlos to be a biased witness with motive to lie. But the appellate ruling means that the case should have gone back to the trial court, Judge Clancy's court that is, to set conditions for inmate Johnson's release. But before that could happen, the state stepped in and hit the pause button. They filed a motion asking for a stay, basically saying, hold everything. We want to take this to the Illinois Supreme Court. And the appellate court agreed. And that stay is the only reason Quadajah Johnson is still in custody right now. So now, defense attorney Ari Williams just made another bold move. She filed a motion to reconsider that stay. In simple terms, she's asking the court to take that stay back. You shouldn't have granted it in the first place. And her argument this time comes down to 3 major points. And point number 1 is that the state hasn't even filed their appeal yet. The state asked for time to go to the Illinois Supreme Court, but they haven't actually filed the appeal. So the defense is basically saying, you're keeping her locked up for something that doesn't even exist yet. Well, in the legal sense, that's actually a powerful argument because it makes the state look premature. Point number 2, the law already gives the state a deadline. Now, there are rules in place that say the mandate should go out quickly within about 5 days. The state has that window to act if they want Supreme Court review. So the defense is essentially arguing there was no need to freeze everything. The system already has a timeline. In other words, the stay wasn't necessary. And point number 3, this violates the defendant's constitutional rights. Well, now this is where things start to get serious because the defense is saying that this delay is causing an unconstitutional loss of Quadajah Johnson's liberty. That's a direct due process argument under the 14th Amendment. And here's what makes that argument hit even harder. The appellate court already said she is not a continuing threat and she can be released with conditions. So now the defense is asking, if you already decided that she shouldn't be detained, why is she still detained now? This filing puts the appellate court in a tough position because now they have a couple options to choose from. They could either deny the motion and then the stay stays in place and Quadajah Johnson remains in custody. The case will then move forward toward the Illinois Supreme Court. And the second option is they can grant the motion. Then the stay gets lifted, meaning that it's no longer valid. The mandate goes through, the one that directs Judge Clancy to figure out release conditions for the inmate. The case will then go back to the trial court, Judge Clancy's court that is, and Quadajah could move toward pretrial release. Absent another power play by the state, Quadajah's headed home to wait for her trial to begin. And well, I'ma say this, that second option is the one that really could change everything real quick. This also tells us something important about the defense's strategy. They're not sitting back and waiting on anything. They're applying pressure, they're building a record, and they're forcing the courts to justify every delay. Because this case is no longer just about guilt or innocence. It's about something bigger, about fairness and constitutional rights. Can the state keep someone locked up after losing an appeal just because they might appeal again? Inquiry minds would like to know. So right now, everything hinges on what the appellate court does next. If they reverse themselves, this could put Quadajah Johnson back on the track for release. If they don't, then this fight is headed straight to the Illinois Supreme Court. And the question becomes, how long can the system delay freedom after already saying that it should be granted? But now, here's what seems counterproductive to me. The fact that attorney Ari Williams would file a motion requesting the appellate judge who granted the stay to reverse the stay. And the real reason I say this is because when the majority decision was made, there were two appellate judges who said Quadajah Johnson should be released. But there was one dissent. That dissent was from Justice Raymond Mitchell, and he very strongly articulated his reasons for dissenting. So it makes sense that Justice Mitchell would vote to grant the state's stay to further appeal this decision to the Illinois Supreme Court. But this time, all three appellate judges signed off on the decision, making this a unanimous decision to grant the stay. Notice whose name is first to sign. But now, attorney Ari Williams, Quadajah Johnson's defense attorney, is expecting the dissenting justice to reverse the stay. No, ma'am. I just don't see that happening. And here's why. Let's revisit the details that Justice Mitchell pointed out in his dissent. And remember, he's talking about the September 8th killing of Romeka Blackman by the hands of Quadajah Johnson. These are the reasons that he believes Quadajah Johnson should remain behind bars during pretrial, and subsequently the reasons he voted to grant the stay. Location, location, location. What Justice Mitchell is doing here is setting the stage, and this matters a lot. Don't let anyone tell you otherwise. The incident that took place on September 8, 2025, which led to the death of Romeka Blackman, Justice Mitchell is saying that this didn't happen in isolation, late at night, or behind closed doors. According to the record, this was a weekday morning, a Monday morning at that, around 9 a.m., on a busy street in Chicago's South Loop area. This is extremely important because it speaks directly to the issue of public safety. We're talking about a time and a place where people are commuting, walking, and dropping kids off at school, just as Romeka Blackman did that morning. So in Justice Mitchell's view, this wasn't just violence. It was violence carried out in a public, high-risk environment where anyone could have been harmed. He goes on to talk about the people who were involved. Now look at who was present. This wasn't just two individuals in a vacuum, he said. You have the defendant, a victim, a shared partner, and critically, children connected to both women nearby. Justice Mitchell is highlighting this to show how layered and volatile the situation already was. Emotions, relationships, and conflict were all intertwined. From his perspective, this isn't just about one moment. It's about the type of situation that can easily happen again, especially when people are connected through ongoing relationships. Now let's talk about the events leading up to the shooting. This is where escalation becomes key. Justice Mitchell said what started as a verbal argument didn't stay there. It turned physical. According to the witness account cited in his dissent, the victim was struck with a car door and put in a chokehold, but then she breaks free and backs away. Justice Mitchell focuses on that particular detail for a reason, because it suggests that there was a moment where the situation could have de-escalated. Instead, it continued to escalate. And that decision-making on Quadajah Johnson's part is central to his concern about future risk. And now we get to the most critical moment, the shooting. Justice Mitchell points out that the defendant went to her car, retrieved a firearm, came back, and then fired multiple shots at an unarmed person. That person was Ramika Blackman. And he emphasizes the sequence: one shot, a pause, then two more shots. And for those still questioning why that matters, it's because in this appellate justice's view, this wasn't a split-second reaction at all. Justice Mitchell is framing this as a deliberate action, even if it did happen quickly. For him, this is evidence of someone who, when faced with conflict, is willing to escalate that conflict using lethal force. And here's another part that stands out in Judge Mitchell's dissent: the aftermath behavior. After the shooting, the victim is dead. The defendant is unharmed, and there's a reported fist bump that took place between the defendant and Carlos Smith. Justice Mitchell uses this detail to underscore what he sees as a lack of restraint and seriousness about the consequences. From his perspective, behavior immediately after the fact can reflect a person's mindset, and that plays into whether or not someone is considered an ongoing risk. Now here's where Justice Mitchell pushes back against the majority justices: the firearm used in the shooting and Quadajah Johnson's background. Yes, it's true that the defendant had no prior violent history and that she was legally licensed and trained to carry a firearm. But Justice Mitchell flips that. He argues that this doesn't make the situation less serious. It actually makes it more concerning. Because in his view, this is someone who knew the law, who had training, who had no violent past, and still made this choice. So instead of seeing this as reassuring, he sees it as unpredictable and alarming, because when you know better, you do better. When you put it all together, Justice Mitchell is looking at the full environment: a public street, near a school, during morning hours, and with bystanders and children around. And this is where he draws his bottom line conclusion. If this set of facts doesn't qualify as a real and present threat to the community, then what does? This is ultimately why Justice Raymond Mitchell of the 1st District Appellate Court believes that detention is necessary. Not as punishment, but because based on what the state has clearly presented, and I quote, "This justice believes the risk is ongoing and cannot be controlled by release conditions," end quote. And that's the core of Justice Mitchell's dissent. He's not just looking at what happened, but what it reveals. In his view, the state proved that this wasn't just a one-off incident, but evidence of a continuing danger to the community, which is exactly why he believes pretrial detention should have been upheld. Isn't it ironic, though, that defense attorney Ari Williams has the audacity to ask Justice Mitchell, of all people, to reverse his decision to grant the stay? Child, please. See, now you playing in that man's face. If you enjoyed this video, please give it a thumbs up and share it with someone who could use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think the appellate court is going to reverse their own decision, or do you think they're going to let it ride all the way up to the Illinois Supreme Court? Meet me in the comments. We can continue the conversation there.